morning. Thank you all for coming today. I want to assure you that we have done our homework on this issue. Going back several years, I think it's safe to say, with between public records requests and time that I have spent in what I call the bat cave of the historical archives, we have reviewed probably in excess of 5,000 pages of documentation of public record. That's very important to understand because there are a lot of pieces and parts that are moving between the casino issue, the 4 casinos, and the extrapolation beyond what they are allowed to do and what the state can do on their behalf, and the extension of the lottery into the racetracks with the VLTs. Please understand also that we acknowledge that the lottery could conduct VLTs, if and only if it's taken back to the ballot and the voters have a say to approve that. In the framework that was instituted in 1973, follow-up constitutional change in 1987 with regard to direct policy, constitutional policy on the lottery, that's set for legislators decades later to put into statute, which they did in House Bill 1, that said that the lottery was always intended to allow for video slot machines. That simply is not factually accurate. It's a lie. So in the course of this litigation, we will have the responsibility of presenting the evidence that we have collected, and we will do so. We have more than 15, I think we have 17 claims in altogether, 18 maybe, that deal with both the casino issue and the lottery issue. I think it's interesting, and as members of the media, if you go back and look at your notes, what was provided to you at the governor's press conference in June, mid-June, the memorandum that was not at that time signed by both Penn National and Rock in terms of that deal that was cut, because on that particular day, just Rock was on board. There were changes then made to that memorandum before it was signed. But the language between the two is very interesting. In fact, I created a chart that compared the deal between the deal that was signed by the voters at the ballot box and set into stone, and then the wraparound deal that came in later through the memorandum of understanding between the governor and the gaming companies, substantially changed the details of the licensing fees, the development costs that the casino operators are required to pay, and Ohio did not come out ahead at the end of the day in those deals. So we would be glad to, I want to share one story that Rob had alluded to in his remarks. Part of the time I spent at the Historical Archive was reviewing the record of the committee processes, floor discussions, votes, and all of those very important details that are held in public record forever. And we did discover that a member of the legislature who was very much in favor of having a lottery, but very much wanted it to be inclusive of other casino-type games. His amendment to the joint resolution only received 4 positive votes. All of the co-sponsors of the joint resolution voted no. We have a very clear record that the Ohio lottery was intended, presented to voters, voted on by the members of the General Assembly to be a paper ticket lottery. Ohio can go beyond that if the process is followed of going back to the ballot and asking the voters to go beyond that. The voters have already expressed their displeasure with the idea of having slot machines at Ohio racetracks numerous times. That's been a part of previous ballot issues. Not as a part of the lottery, but as a part of installing the slot machines at the racetracks. And if the lottery is to be expanded, that's the process to follow. Not memorandums of understanding, not even statutory changes. It must be done through the Constitution. And we would be involved in that process as well.
Well, when we look at that process, it's already happened once in relation to the 2009 amendment. they put an amendment on to move locations in Columbus, correct? The question is, had the current governor been in office then, would they have needed an amendment? Would he have said, we can move this because we're going to move it? That's why we're going to move it, because we're going to move it. We also looked, remember, in 2002, when the lottery entered into the Mega Millions game, there was also litigation that came forth then, and we prompted that litigation and moved forward with it. And one of the areas that we won in that case was a shell game that was being played with the money. All of net proceeds were not going to education in 2002. And the court ruled that that was not allowed, that all the net proceeds must go to education. The same questions arise here. If VLTs, excuse me, using their language, not our language, if slot machines are part of the lottery, then why aren't all net proceeds going to education in the same way that the court's already ruled? That's another point that is to be made and to be argued.